walked into his school, high school, and I explained to them who I was, not that I was a criminal defense lawyer. And this was years after he was there, and they said, "Oh, how's Marcus?" They were extremely fond of him in terms of memory. And I present this to the court to show as forcefully as I can that this case is absolutely an anomaly as to who Mr. Aries really is. In terms of redeemability, in terms of what kind of citizen that Mr. Aries can be, and this is really regardless of what the court ultimately sentences. He will be this person, an upstanding person, whether he is incarcerated or whether he is not. And at some point, my hope is that he's no longer incarcerated, and I firmly believe that he will be a truly good citizen. And with that, if the court would allow him to read his first statement.
Sure, just a moment. All right, sir, you may address the court. Make sure that I give this instruction to all those who are here. Make sure you speak slowly so my reporter can take down everything. And I first want to indicate you're under no obligation to talk to the court. And I'm sure you discussed that with your attorney, right?
Yes, sir.
Okay, so I just want to make sure that anybody viewing this knows that this is a statement that you wish to make, and you're under no legal obligation to make it, and that everything that you're saying is being taken down. So do you understand all that?
Yes, sir.
Now, with that in mind, do you wish to address the court?
I do, Your Honor.
You may.
All right. Before prison and incarceration, I felt drawn to a fast lifestyle, not books, learning, or studying. School never held my attention. Since I've been locked up, I've read hundreds of books. One book in particular really spoke to me and helped me change my way of thinking. That book was the book on Socrates' life. It made me realize how poorly I had prepared for life's challenges, or even life in general. Now looking at a lengthy sentence, I know I'll confront many challenges. By reading philosophy, I learned the importance of introspecting as that first step towards change. The more I think and introspect, the more I realize I need to change. Before my incarceration, my thoughts were shallow. I never gave any consideration to what it would mean to define success or what that meant to me. Instead, I thought about what I wanted in the immediate moment, like material things, such as cars, places to live, or clothes. I didn't comprehend how daily decisions would influence the rest of my life. Like the friends I chose, I lived for the moment. By reading that philosophy book, it helped me to introspect. Introspection brought me more clarity. I reflect on my years in school or my life at home, even all my relationships. From my earliest memories, I looked for the easiest way. As I'm a hard worker, I could also be very lazy, especially when it came to school. I would ignore the teachers who invested so much time trying to teach me. I had no discipline. Whenever I saw opportunities, I acted quickly, without thinking about what would follow. I didn't hesitate to lie or cheat if I felt by doing that would serve my interests. The more I introspect, the more disgusted I become with my earlier decisions. Those thoughts and decisions led to the young man I have become, a person locked inside a cell on his way to prison. As I continue to develop my thought process, I'm starting to think that I'm not in jail because I made a bad choice. Instead, I'm here because I lack discipline and foresight, the ability to think about my actions and to consider the consequences. I've lacked this since I was a young boy. I would choose the easy route instead of preparing for success. Rather than surrounding myself with good role models, I befriended people with character flaws like mine. And as I reflect on these things, I can see how all these earlier decisions put me on a pathway that influenced the person I was. With all this, and the more I think about my life in the past, the more I realize how my earlier decisions would influence the future I would build. Although I don't know what sentence you, my judge, will impose, I do understand that I will have to serve many years. But I plan to use those years on setting myself up for success in the future. I will come out better and more prepared to be a productive citizen and a better neighbor. The time will not be wasted, and I will not focus on being a better prisoner, but instead being a better citizen of society. I want to lead a positive life. I want to reconcile with society and redeem my bad decisions. I want to earn a second chance, not just be given one. I don't know what challenges prison holds for me, but I do know that I want to return to society a better person. Coming here and experiencing incarceration made me want a different life. I realized that if I continue to associate with people who break the law, I will always have trouble with the law. That's why I strive to be different and not conform to the prison lifestyle. I won't become institutionalized or get involved in the politics of prison life. I'm focusing on my future. I have matured much since my arrest, and I will continue to work towards showing how I've matured even more in the future.
Thank you.
Thank you.
All right, now I'll hear from the people, and you may address the court.
Thank you, Your Honor. So the first thing that I want to address is the impact this has had on Aiden's parents. I don't think anyone can stand and judge a man or a woman who's been through what they've been through and look at this moment and say, well, they're not here. I think the courts had a long enough span to understand the effect that a murder has on a family and the range of behaviors that we'll see this being at one extreme. The reason I start with that is because we sat here all together and we listened to a depth of pain I have never, ever heard before. When Mrs. Clunan was trying to find some way to help her boy as he lay dying. And I want that to be the starting point for this, because Mr. Arias, and I appreciate his comments, is talking about earning a second chance. Earning a second chance first begins with the payment of the debt. And punishment is part of this process. I was kind of waiting. I know Mr. Bethune said he had two statements to make, but I was waiting and I didn't hear Mr. Arias mention Aiden's name. I think that's significant. So the first thing is to remember what Mr. Arias took. The second thing is to think about what actually got Mr. Arias to this point. And based on his interview and the evidence before the court, this was an unoriginal plan. This was not something he thought up that no one in the world had ever done or thought of. He had seen the results of gun use, understood guns, and made that choice to put that loaded gun in his car, looking for someone who was going to disrespect him or treat him in a way that he was seeking. This wasn't a self-defense, it wasn't provocation. He wanted the world to know what he was capable of. The last thing I want to talk about is what he took from everyone in the community. What he took was that he removed our neighbor's sense of security driving on our freeways. What he instilled in our community was fear. And he stoked a divisiveness and an unwillingness for neighbors to act cordial to each other and to treat everyone with suspicion. I don't think that can be lost. I know how old he was, I know how old he is, I'm well aware of the laws. When you look at this crime and his decisions, which were his alone, to think about mitigation only after we think about the other factors in aggravation, the only place that I can land, that our office can land, is the maximum sentence of 40 to life. So that's second-degree murder, 15 years to life, and for the use of the gun, the 9mm that he customized, an additional 25 years to life. I'm happy to answer any questions about it, Your Honor, but our position is pretty plain.
Before I turn it over to the defense, I do want to ask you about the interplay of these sections that were set forth in the brief filed yesterday. The rules of court, 4.43, the 1385, and then the penal code section 3051, if you care to comment on that, as to does that apply, and if it does, to what degree should the court apply it? It's, I think, undisputed that the defendant was under 25 years of age. As we know, the legislation in our state in the last 4 to 5 years have talked about youthful offenders. I think that's the term. So I want to make sure you get an opportunity to address the court on the positions that the defense has taken.
Thank you for that. So I do fully understand where we are in terms of the youthful offenders and Mr. Reese's age. As for the sections quoted by defense, I'm familiar with those as well. And arguably, the court can consider this information in terms of the sentencing beyond just the parameters of a traditional Franklin hearing. So I don't want to really spend my time on that. But what I do want to say is, I think it has very limited effect. I think that the reports of the doctor, and I've been through them, don't move our needle, quite frankly, because we heard from Mr. Reese, who had the benefit of time and reflection because of how long the investigation took to catch up to him, exactly what his motivation was, exactly what his purpose was, and exactly what the point was. So a doctor's report coming in now without the benefit of cross-examination, I think the impact and I think the use is marginal at best. So I'm asking the court to obviously to consider it, as we want our complete record. I don't think the people gain anything by keeping out the opinion of a doctor, but I do think that the scope, the impact on this sentence and on this case is extremely limited and narrow.
Anything further?
No, thank you, sir.
All right, thank you. On behalf of your client, to address the court, I do have a question about the doctor's report. In interviewing your client, it appears that most of the information, if not all, is coming from interviews with your client. Obviously, he was familiar, or she was familiar with the facts and circumstances of the crime. But when I read the report, it appears that the basis of it is from information that your client gave. And I did not see, and I read it a couple of times yesterday, but I did not see a connection between the childhood trauma that was described and an opinion as to whether that was a factor in the commission of the crime. Now, you advocate that in your brief. But if these rules apply, and that is specifically 4.43 of the California Rules of Court that somewhat talk about factors for the court to consider to apply an upper, middle, or lower term, which this is an indeterminate sentence. 1385 C2E, which also talks about the childhood trauma, there needs to be, for the court to conclude that the trauma, the childhood trauma, was a factor in the commission of the crime. So those are a couple I'd ask for you to address. The other is 1385C 2F says, again, that's a brand new section of the court's inherent power to dismiss, which is, I believe, what you're asking the court to do, is to dismiss the 12022.53, which obviously has the effect of making the defendant eligible for probation. But 1385C2F prohibits that in a violent felony. So I'd like your position on that. And then finally, the 3051B2 section that you put forth, the way I read that is the law passed by a legislature that when someone is of the age of your client, it is now required that after so many years they get a parole hearing. So in summary, when I make this decision, the way I look at the law is that I'm looking at whether to dismiss the enhancement for count one. I mean, when it all's said and done, and I do not read any of these sections that guide me and mandate that I consider certain factors as if this was a determinate sentence. I believe I can consider it, and the weight that I put onto it is my decision, exercising my discretion. All right, so that's what I'd like for you to address at this time, along with any other statements you want to make to the court.
Thank you, Your Honor. And I do appreciate very much where the court is with respect to the law. The issue that we have here is if we didn't have California law where it is today and we had it where it was, let's say 10 or 15 years ago, the court would not be in the same position, obviously, in terms of what to do with these statutes that I believe are in many ways conflicting. Because let's assume for the moment that we didn't have the 3051 statutes, we didn't have the court's discretion with its ability to strike the enhancements. This wouldn't be much of a discussion, in all honesty, would it? The people would be asking for the max, and it would be extremely difficult for the defense to ask the court legally to do anything. But that's not the status of the law today, and I impress that upon the court to say that the idea that somebody who is 25 years or under has a different sentencing scheme than somebody who is over that age is where we are in the law and what that means in terms of ultimate culpability. And unfortunately for the court, it's on the court to decide what that is. And so, to be perfectly frank, I put it in the sentencing brief in that way because if a traditional factor in mitigation is what was the age of the client, right? And over here we have all these other laws that codify that concept in terms of what Mr. Ariza's ultimate rights would be for a parole hearing, then I think this sentencing, unfortunately for the court in a lot of ways, is an exercising of what we do with these laws and how that works. Let me put it this way. Can the court sentence Mr. Ariz to 40 to life? I believe the court has the legal authority to do that, obviously. But when we have a law that comes in that says, hold on, we have to factor in his age. We have to factor in these things because the sentencing scheme is different. So does the 40 to life sentence for the court become largely academic at that point? And at what point, if it's a 400-year sentence, hypothetically speaking, and he's eligible for parole at 25, at what point, and I'm not by any stretch of the imagination making a cruel and unusual punishment argument at this point. But we can see at some point if the law is saying, look, we have to recognize the age of the client. At what point does the sentence over what the law contemplates simply become academic? And so that's why I put it where I did. With respect to non-statutorily eligible for probation, I believe that it is my ethical obligation to ask for that. And I believe that there is an unusual circumstance argument that I think that the court can certainly deny. But I think from where I'm standing on behalf of Mr. Ariz, I think I'm obligated to make that pitch.
But legally, I just want to make sure, the way I read the law is, that if the court, in exercises its discretion under 1222.53, which the law has changed, we have legislation that says the court is under a duty to consider dismissing or striking that enhancement. Whereas we know that the law before that was a prohibition very similar to a person that was suffering a serious strike. My question is, the court can't get to a consideration of probation until and only if the court dismisses the enhancement under 12022.53, because under 12022.53, the H section, if I don't dismiss it, I don't strike it, the defendant is statutorily ineligible for probation. So that's why I'm trying to establish that what the decision is here is whether the court should dismiss the enhancement that the jury found is true for the use of the gun causing death of this child.
Understood, Your Honor. And
Okay.
I understand the dynamic that the court's faced with. And it's also in light of these new laws that we have that situation, right? Because if we didn't have his age as a factor, and we didn't have what the law is saying is that, well, regardless of what the court does, he's eligible for parole at 25 years of service, right? Now, that's part of the court's analysis, because if the court strikes the enhancement, we are left with probation, or we're left with 15 to life on the second degree.
The reason I'm saying that, I think it's in everybody's interest that what the court does today is doing what the legislature has required the court to do. I think the last thing people want is that conditional remand because we didn't dot the I's and cross the T's. So that's why, and this is the court's analysis, to me, it is these legal provisions that you've cited, the court can consider, but the court actually isn't required to. If the court does, the court gives it the weight it deems appropriate. And then second, to get to even a consideration of probation under the statutorily presumptively ineligible, the first thing that has to happen is for the court to dismiss the enhancement that you've asked the court to do under 1385. I just want to make sure that we're all in agreement. That's where we are, and we all have our lanes. We all have to make our decisions. And in a few minutes here, there's going to be what can only be said a very significant decision that the court has to make. And I just want to make sure, as officers of the court, your advice that the court is proceeding the way that the court should do, especially in light of recent legislation that tells, as you've suggested, the court to focus on various factors such as age and childhood trauma. So I just put that out there because I want to make sure that the court is following the law. So go ahead.
And I do think the court has absolutely outlined where we are. And I do stand by the position that the appropriate sentence here is to strike the enhancement for the number of factors that I have included. The childhood trauma issue is one of those factors. But in the defense brief, I've also alluded to a number of other mitigating factors. And this is also under the guise of the fact that the people have not alleged any aggravating factors whatsoever. So all the court has is the mitigating factors.
But they're, because it's a indeterminate sentence, they're not required to allege aggravating factors.
That's correct, they're not. They're not.
Right.
Just as the court's not required to follow through with the defense request. But it doesn't mean that from the defense position that the request is what I think is the right thing to do. The people have talked about punishment. Nowhere, at no time, has Mr. Uri said that he should not, and he's not willing to pay for what he's done. He absolutely understands that and has understood that from the very beginning. The people talk about the benefit of time, inferring that somehow that Mr. Uriz could come up with something. And I submit to the court that from the very beginning, as I talked about in my brief, when he found out what actually happened, what the result was from his actions, he expressed remorse at the very beginning when he went to speak to, ultimately was the co-defendant in the case. First opportunity he had to speak to the police, he gave a full confession as the court heard. There was never an excuse for Mr. Uriz, ever. In fact, just the opposite. When the police pressed him to have an excuse, he said, I don't have one. And it's important for the court to consider that the benefit of time that the people allude to was used by Mr. Uriz to continue to tell exactly what his truth was, that he made a horrible, horrible mistake. He's owned it since the beginning. And in his introspection letter, the court can hear that he's not making any excuses today. He's perfectly willing to accept whatever the court gives. And I think that's a very important point to make. As his advocate, I am making a position in terms of what I think the court should do and what I think is the right thing to do. Because the reality is if you give Mr. Uriz 15 years to life, or you give him 40 years to life, the pain that the victim's family suffered doesn't change. Mr. Uriz understands that pain. And he will be reading another statement that addresses some of that. And so I understand the court's position. In light of the new law, I'll just summarize the defense position as this. In light of the new law, where we recognize the dynamic of the human condition in terms of what trauma does to you, when we recognize that a 24-year-old making an act is different from a cerebral concept than somebody who is perhaps 40 or 45 or 50. The law is recognizing that. And so the defense position very simply is, if the law is saying that a person of this age is parole eligible at 25 years, the defense position very simply is that the sentence should not go above that. And I think, from my perspective, I always want to try to convince the court, and I understand the uphill battle here. And from the defense position, when I see somebody like Mr. Uriz, when I first met him, One of the things that I look at is watching these men and women become institutionalized and hard. And I am amazed that Mr. Aris has not done so. He's still as nice of a guy as when I first met him. His goodness is infectious. Never bitter. Totally accepting of the court. It's extraordinary to see. Mr. Aris is an incredible artist, and he draws pictures. And he drew me a picture yesterday that he gave to me. And he explained the picture to me, and I won't share it with the court, but what he explained is that the way he drew the picture was that it was to cast out bad spirits. So for Mr. Aris, it wasn't, I want to wish you luck in the sentencing, because that would arguably come back to me being successful for him. That's not what he was wishing me. What he was wishing me was the bad spirits go away. And so, as much as I'd like to try to think that I'm a good enough attorney to tell the court something that's going to impress the court enough to agree with me, I think that perhaps Mr. Aris's final statement is probably the best way to do it. So, with the court's permission.
I would like to start by saying that Aiden was like such a beautiful, precious, sweet, and happy little boy. He was a son, a little brother, and a friend to others. He looked as if he brightened up the world everywhere he went, and truly one of God's little angels. And I am so sorry for ever hurting him and for the pain that he went through because of me. He never deserved it, and neither did his family. Miss Clunan, I am truly sorry for taking your beautiful son away from you. There are no words for how deeply and truly sorry I am for parting you and your son, or putting you and your son through so much pain. And not only you and Aiden, but your entire family has to suffer this heartache and pain because of me, and for that I am extremely sorry. Every night I pray for Aiden and your family. I know the burden and pain that you carry will never change, but I pray that God will help you with how you carry it, and that you may find peace and happiness again. I am so sorry, Miss Clunan. I also want to apologize to everyone else. Not only did I victimize the family, but I feel I victimized the first responders, the hospital staff, the investigators, the DA, my entire defense team, the judge, and the jury, and my family, and Winnie and their family, or Miss Lee and their family. I'm so sorry for putting everyone through this. None of you deserve to see this, but I put you through it. The effects of my actions have spread to everyone like dropping a rock in a pond, and I hurt everyone around me. I affected everyone in some way. Whether it be big or small, it doesn't change the fact that I am responsible for everyone's trauma, heartache, pain, and suffering. And for that, I am also deeply sorry. No words to you would alleviate your pain or soften your hearts to me. So I will end by saying this. Dear Lord in heaven, forgive me. As I stand before this court today, accountable for the terrible road I have chosen, I know that one day I will also stand before you, Lord, still accountable to you for my actions in this world. Lord, I pray you will carry Aiden's family in your loving arms every day. Open their eyes to your grace. Give them peace. I pray you stay with me also every day. I pray, Jesus, that you will not stop looking for me, your lost sheep. I have strayed so far away from you, and I need you to guide me back home. Lord, I beg forgiveness. I pray, let me praise your name for Aiden's life every day of what's left of mine. And in Jesus' holy name, my life is in your hands. Amen.
Anything further on behalf of the defense?
Submit.
All right, Mr. Feldman, I'm going to allow you to comment. The defendant did make an additional statement. I had him go first and let you comment on that. And so the court is going to allow you to comment if you so desire. And we'll go ahead and proceed.
Thank you, Your Honor. I don't need to repeat anything I've said. I think we can just look at it for what it is. Violent felony, jury's finding statutorily ineligible. Versus, on the other side, what is clearly a sincere apology and a prayer. But what we're talking about is the fabric that holds us all together, which is following the rule of law. And I think the court's laid it out. I think the law is very clear. I think the weight to be given to any doctor's note is in the court's hands, and we fully trust in that. But in this situation, there is no legal, there is no other justification outside of that that would justify the striking of the gun enhancement. Unless the court has questions, that's all I have.
I don't.
Thank you.
Any concluding comments? Get out of your comment.
No.
All right, the court will now move to sentencing. The first thing that the court is going to do is go through the fines, and this is required in every case. The court is going to impose a $40 court operation fee and a $30 criminal conviction assessment fee on both counts 1 and 2. Court is also going to impose a $300 state restitution fund fee, and the court is also going to impose a $300 revocation fine. The latter is stayed pending successful completion of either probation or parole if that were to occur. With respect to the credits, the sentencing report does indicate dates up to today, and the court indicates that it will then put in the abstract or in the minute order 1,042 days of actual time, as what was pointed out by the people. Because of the conviction of murder, there are no conduct credits. Would the defense agree with that? All right, on behalf of the people, do you have to take issue at all with the number of days of actual time in custody?
No.
All right, now let's go to the next area, and that is restitution. The probation department said to be submitted later. However, the people did submit a restitution order, and I think that has to do with reimbursement of the victim's compensation fund. Am I correct on that?
Yes.
Is there any other restitution other than what you have put in the restitution order?
We have reached out to both Aiden's father and mother, and they both declined any further restitution.
Well, what the court's going to do, my tentative is to execute the restitution order as submitted and reserve jurisdiction in the event that there is further restitution having to do with the impact of the crime. All right, any issue with that on behalf of the defense?
No issue.
Okay, now we go to the actual sentence. The actual sentence. The first thing that the court should do is to impose the sentence on count 1. The court, at this point in time, will impose 15 years to life on count 1, which is the punishment authorized by the statute. The court will now go to the enhancement. And as I've attempted to articulate, if the court dismisses the enhancement, the court then goes back and determines if the defendant is statutorily eligible, and I will revisit the sentencing on count 1. So the issue for the court today, and I think everybody has agreed, is whether the court, in its discretion, should strike the additional 25 years to life under 12022.53. The court in that has considered the defendant's statements, considered the report that was authored by the doctor that was submitted to the court yesterday. I've considered the fact that the report does indicate childhood trauma, and I've also considered the fact of the age of the defendant at the time. And before I get into the final decision, I'm assuming, as the people brought out, the court is making the report of the doctor as part of the sentencing, so that this constitutes a Franklin hearing. And the defendant has had the ability to set forth the factors in the event that that becomes important in the future. But I just wanted to make sure, are there any other information in terms of the Franklin hearing that the court is required to conduct at this time because of the age of the defendant at the time of the sentencing, at the time of the offense?
The only defense request I have specific to the Franklin issue is that there is some law that indicates about what the defense ability to reintroduce Franklin factors after the court sentence as we're going to our parole hearing. And I would simply ask that if new information that is available, that defense retains the right to introduce that to the extent that the law allows that. I don't think that's really a concern for the court today. But other than that request, no.
All right, you've made the record on that. People, do you wish to be heard on that?
No, Your Honor, thank you.
All right, so now let's get to the factors that the court has considered in exercising its now discretion to whether to dismiss, strike at 12022.53. As I've indicated, I've taken into account what has been reported as the childhood trauma of the defendant. I've taken into account the age of the defendant. I've taken into account also the defendant's statement here. I just cannot draw a connection between the childhood trauma, what has been reported about the lack of development of frontal lobes of individuals at that age, as well as his age, and in looking and reading and presiding over this case, this defendant didn't commit any crimes until this particular day. He didn't. He's driving on the freeways. He's being subject to, I think, what we all see every day. And there was no impulse other than on this particular day. And I just can't connect that in this case, that his childhood trauma or his age was a factor in the commission of this crime. We have a 6-year-old in the back seat, the most vulnerable victim that you can even imagine, going to kindergarten, being driven by his mom. And she, the mom, did some driving maneuver that caused girlfriend to give the peace sign, that caused the mom to flip off, and that caused you to get behind the car. And in that particular moment, you had the power. And the power was that handgun. And whether it was to impress your girlfriend, to release your anger, you fired. And that little boy died. When all is said and done, that's what happened in this case. I cannot, as the sentencing judge, look at the facts and circumstances of this case and see any stretch of the imagination, a non-legal justification such as being provoked or anything other than, I'm going to get back at her. And that's what happened. And as the people have brought out, and there's a case that our United States Supreme Court decided almost 30 years ago called Payne versus Tennessee. And what is an aggravating factor of a crime is victim impact. I don't think the English language can even attempt for anybody to even describe what Aiden's mother went through after he said, ouch. She pulls over and her little boy dies in her arms. I don't think anybody can even comprehend what the rest of her life is going to be about how her little boy died. The court places great weight on that aggravating factor that I'm allowed to do. And as a result, the court, in exercising its discretion, will not dismiss the enhancement. The court will impose 25 years to life consecutive to the 15 to life for count 1, for a total of 40 years to life. With respect to count 2, I'll ask the people. I do agree with the defense. I think the people also perhaps share in that it is merged pursuant to Penal Code Section 654. Would you agree?
I do, sir.
So the court is still required to impose a term. The court will impose and follow the 1385 now, because there was not a submission of factors of aggravation having to do with count 2. Am I correct on that on behalf of the people? All right. So the court then, in exercising its discretion under the California Rules of Court, will impose the midterm of on that, and the court will also impose the 25 years to life, but it will run, it is merged pursuant to Penal Code Section 654. Now, before I get to the final order to the sheriff, I do want to ask, it's the court's habit, does the people see any sentencing errors that the court has made in terms of the imposition of the sentence?
No, Your Honor.
On behalf of your client?
No.
If I can have just a moment. Do you think anything else before I give the appeal rights to the sheriff? Okay. Sir, I need to address you. You have a right to appeal the sentence of the court. And this is very important. I need to know that you understand this. It is your responsibility to file the notice of appeal. You must do so within 60 days. It must be filed with the clerk of my court here. It is your responsibility. I'm sure you've discussed that with your attorney. If you do file a notice of appeal, the appellate court will do 2 things. They will appoint an appellate lawyer for you at no charge, and you will also be provided a transcript of the necessary proceedings. What's important, and I want to make sure you understand this, is that it is your responsibility, and your attorney can do it, but it's your responsibility to file the notice of appeal within 60 days today. Do you understand that?
Yes, Your Honor.
Do you have any questions?
No, Your Honor.
All right, anything further on behalf of the defense in terms of the sentencing or the notification of the appellate rights?
No.
On behalf of the people?
No, Your Honor.
All right, the sheriff at this time is ordered to transport the defendant forthwith to Department of Corrections. Court's in recess.
Thank you very much.